Super, very good. So the seminar that I've been giving the last few years has evolved over the many years, and I used to do all kinds of different seminars, and this is kind of the boiled down version of all of those different ones that I've done in the past. And I've had really, really good luck, and I call it the Beneficiary Seminar. And this came about basically because last year I lost 6 clients. And in doing that, the ones that I had prepped, that had gone through this, what I'm going to walk everybody through, it was so easy that it was unbelievable. The ones that didn't have this all set up because they didn't come to me and say, I want to go ahead and do this, we're still working on it a year later. Trying to get through the estates, and so we're going to talk about that whole thing. And so we'll go ahead and start off with, these are documents that every one of us should have, whether or not you're a client or advisor. So when I go ahead and talk to you guys, I'm really talking to you as an audience and as the advisor at the same time, because we all should have these in place. And so the first one that we need to go ahead and talk about, and this is probably one of the most important documents that anybody can go ahead and have, is the power of attorney. There are 2 different types of power of attorney. There is the durable power of attorney, and then there is the medical power of attorney. With the durable power of attorney, you are giving somebody else the authority to do everything you can go ahead and do. So normally what will happen is the husband and wife will make each other the power of attorney, and at the exact same time you have to go ahead and name a contingent power of attorney, so that not if, but when one of those dies, those people die, we have somebody else that's going to go ahead and step into that person's place. With the power of attorney, there is nothing that that person cannot go ahead and do that you can go ahead and do. So it's a very powerful document that you're giving somebody else the authority to make decisions for you. And I give you a couple of real examples that just happened. I had a client of mine who, the husband went into a nursing home, had a stroke. The wife comes into my office and says, I want to deed a piece of land to my sons. The land is owned joint ownership between the husband and the wife. Can she deed that property to the boys without his signature?
I don't think so.
Of course not. There's no way to go ahead and make that happen. So because of that, that piece of property is stuck until what happens? Until he dies. So, right? So there's a prime example where you want to go ahead and do some gifting, you want to have the ability to go ahead and make a decision, and you don't. And with this document, which up in my neck of the woods costs about $100 to go ahead and have, I have salvaged literally hundreds and hundreds of thousands of dollars worth of real estate assets that, with that one document, because I had the ability to go ahead and gift.
I had a client ask me yesterday, he said he's a millionaire, he's got probably $70,000, $80,000 a year coming in from apartment rentals. Now, he has his wife on the checking account, and so what happens if he's in a car collision, and he's unconscious for 3 months or a year, depending on a coma? Can she take that money that's going into their joint account? Can she have access?
Yes.
Okay.
If she has the power of attorney, then she'll be able to.
Well, she may not have power of attorney. He doesn't. I asked him. I said, do you have power? He said, no. I just have a bank account with her names on it.
With her name on it?
Yeah.
Yeah, so if she has signature authority, she'll be able to go ahead and actually reach into that account and be able to move money around, but she may not be able to go ahead and run the business. So that's why I'm such a big proponent of the power of attorney, is that you need to go ahead and have somebody in place in case those type of things happen. There's a prime example right there where somebody's in a car accident or a coma or whatever the case may be. You need to have plan B if I don't come out of this thing. Not if I die, but what happens if I don't die? That I have the ability for somebody else to step into my shoes to keep this thing running for some period of time, okay? So on the durable power of attorney, here's another example where this just happened, is that the husband, once again, goes into the nursing home, and the wife wants to sell his pickup truck, right? And it doesn't sound like a lot, but our neck of the woods, the truck is $45,000 plus the plow, right? So we're in this thing for like $48,000, and she will, obviously he's never gonna plow again. She needs the money. Can she sell his truck? No, you can't go ahead and sell it, right? And so here once again, she's stuck with an asset that she can't go ahead and move, right? So these are prime examples where the durable power of attorney solves all that problem. As a financial advisor, what happens when one of your clients ends up in a nursing home or the inability to go ahead and make decisions, and they need to make a withdrawal to keep him anyplace. Can the wife go ahead and call you and make a trade inside a brokerage account or an IRA and withdraw money without a power of attorney? Right? So these are very important documents to have in place. Now let's go ahead and talk about the medical power of attorney. With a medical power of attorney, this is you are giving somebody the decision, the ability to go ahead and make a decision over your medical welfare, right? Not only who pulls the plug, but what kind of care do I want to go ahead and have if something happens? Here's a real story. I gave this particular seminar, and then a year later I gave it again at my credit union. And just so that you know, as far as the numbers go, I usually get a 1% response. So I go ahead and target everybody 62 years and older. We can run that inside the credit union. I send out the postcard, say we're having a seminar. I get 1 to 2% of those people will go ahead and show. So it's a pretty good return. That's actually probably about the best you're going to go in. It's probably a little bit better than you get out in the regular public. This person comes, I give the seminar, they take all my advice and they go ahead and do it, except on Christmas Eve, they're in a car accident. Both the husband and the wife are in a car accident. And he's at my next seminar, and he stands up and says, Steve, do you mind if I go ahead and tell a little story? And I'm like, you don't know where this is going, right? You're kind of like, you're in the middle of my seminar. And I go, okay, go ahead. And he says, I was in a car accident, but we failed to go ahead and give we had the medical power of attorney done, but we failed to give it to the person and notify that person. They were in the safety deposit box at the bank. So not only is it important to go ahead and do the actual document, you need to go ahead and give it to that person, because now both the husband and wife are in the hospital. Nobody can go ahead and make a decision, and nobody knows who that person should be. Okay, we'll talk a little bit more about that in a second. So with a medical power of attorney, it not only does it give the permission for the person to go ahead and make the decision, but you have to have a conversation of what heroic measures, if any, that you want done. You just have that conversation. It gives them the ability to go ahead and do that. So the power of attorney will go, whether it's durable or the medical, will go ahead and last until what?
Death.
Death, the big D. Then what takes over? The will. A lot of times I will go ahead and ask clients, do you have a power of attorney? And they will say, no, but it's okay because I have named so-and-so as what we used to go ahead and call the executor of my will. It's now called the personal representative. The personal representative of the will. The power of attorney has power only until last breath. Then the will takes over from there. The will has absolutely no power whatsoever until somebody passes away, then it takes over. With the will, there's some decisions that you should go ahead and prompt your clients. There's some decisions that they have to go ahead and make. Number one, who is going to be the personal representative of the will? He's that person that's going to go ahead and sell the
Is that what
estate.
you're looking for, the executor?
The executor is what they used to go ahead and be called. Yep. And so they actually changed the language so that it's actually called the personal representative. Yep. But it used to be the executor. So who's going to go ahead and do that? Now there's a lot of things that people don't think about. So we always say, well, we know who the beneficiaries are going to go ahead and be, right? Those are usually the children. The real question is, if something should happen to one of the children, who ends up with that children's share if they predecease you? So let's say that we have a number of different children. The question becomes, if something happens to one of the children before you, who gets the share? Does the other child get the share, or does it go down their line? So if it goes down the line, it's actually called per stirpes. That's exactly right. And if it goes to the other child, it's called pro rata. Okay? These are decisions that they have to go ahead and make before we put them in front of an attorney. If you have this all worked out beforehand and have this conversation, it will save a lot of time and a lot of effort. So the will go into effect upon the first person's death. So the exact same thing. The husband and wife will go ahead and leave each other all their stuff. And then, not if, but when the person dies, we have to go ahead and know who gets what's left in the estate and how it's going to go ahead and be divided if something should happen to one of the
Now,
beneficiaries.
per stirpes means the children of the...
Yes. It'll go.
Okay, it doesn't go to the husband if there's no children?
So assuming in this particular case that we're going to name each other the husband and wife beneficiaries and then the children after that. So we assume that one spouse dies, it all goes to the other spouse, and then when that second spouse passes away, it's gonna go ahead and go down the line to their children, or their children's children, or their grandchildren at that point. But you have to go ahead and make that decision. And the way it really gets tricky is when you have his kids and her kids. That's when it gets really tricky, okay? So we've got the power of attorney and the will, and the one thing that I've just started doing, and this is because of that last presentation that we had, and I forget the guy's name that had the,
Zan.
Mark Zinder?
Mark Zinder. And I don't know if you guys have ever had taken the time, but I've actually ordered a bunch of
I
these
got one of
keys.
those.
And just to let you know, I think this is gonna be a great selling opportunity for all of us. So this is what it actually looks like right here. When you go ahead and print off the forms itself, it's pretty simple stuff. It's primary information, dates of birth, what you're allergic to, emergency contacts, and all that type of stuff, and you put it right on here. So what you'll do is, after you go ahead and meet with the attorney to go ahead and have all this stuff done with it for your client, you're gonna scan some of this onto here. So the medical power of attorney, not only will they have all of their allergies and all their medication, all that stuff, but who is the medical power of attorney? Well, if it's on here, it's on their key ring, and they're in an accident, they simply plug this into their computer. Now they got all that information,
That's
and they know
awesome.
who to go and contact.
That's awesome.
So I think this is, as we go ahead and motivate our clients to go ahead and get their financial house in order, then this is gonna be a great way to not only make sure that they've done it right, but it'll also make sure that we can go ahead and actually charge a fee as a huge value added to our client. Say, you know, these keys cost $25, so if you say, we'll go ahead and put a package together with all this and charge them $100 for putting that together to take care of it, it'd be well worth it. I don't know of anybody who wouldn't go ahead and do that, okay? Any questions on power of attorney or wills?
Well, just on the power of attorney to the children.
Yep.
What if the daughter's married to a jerk? I mean, could they put, you know, can they go pro rata to, well, how would they, you know what I'm saying? How do you protect?
Well, per stirpe protects him from inheriting anything as a son.
Well, if they don't have any children, it'll go to the other.
Then it goes to the other.
So per stirpe takes
sibling.
care of that. Okay, sorry for the.
No worries. So, and this is very important stuff, and if you don't take the time to go ahead and do this, can you imagine if there's no decision made and then there's a death? I mean, so I'll give you a real example that I had a client that came in, we're rolling a 401k, he's literally gonna go ahead and retire. In all paper mill workers, they have 5 weeks to go ahead and have vacation. So what everybody does, they retire January 1st because they get 5 weeks in that new year. So we're waiting for that 5 weeks to go ahead and, so he can collect his vacation time. And so in the meantime, I meet with him and I said, do you have a will? He says, no, I don't have a will. And I said, you're gonna have a will. And so that's just the deal, because I've lost some clients recently. So I called my attorney, we set up the appointment, we rolled one 401k, his old 401k. I said, we'll wait 5 weeks before we go ahead and roll the next one, right? We just get done, we'll go ahead and roll that, be easy. Yep, no problem. Comes in, we ink the will on February 18th. He dies March 22nd.
Wow.
But what we failed to go ahead and do, and failed to go ahead and recognize, was that on his 401k, the beneficiary was his ex-girlfriend,
Oh my gosh.
okay? The ex-girlfriend has now passed, okay? So now who's it left to?
He's
Kids,
an
her
intestate.
kids, her
Unless he had
family.
a contingent, it's his estate.
His estate. What would have happened if he didn't have a will? His children would have ended up with it, but in his will, he specifically didn't want his children to have a nickel. So if I hadn't prodded him to ink the will, none of the things that he wanted, to include leaving his house to his ex-girlfriend's daughter. This isn't pro rata, this isn't in stirpes, this is never
Oh, that's
land.
what he wanted.
That's what he wanted,
Oh, I
to
got
leave
you.
it to his ex-girlfriend's daughter, the house. The kids would have gotten everything, which is not what he wanted. So because of that,
They
because
must have ticked him off.
I don't know what he did, I didn't ask. All I knew was that the way he was sitting, if I hadn't done what
Yeah.
I've done, none of his wishes would have been carried out, none of them. And so that's a real example that just happened to me that drives this stuff home and what makes it so important.
Can I ask you a question? You rolled over his 401.
One.
You had paperwork there in force. Had it
Yeah.
rolled by then, or would that have been a governing document that said his old girlfriend was the thing, and who does he want on the new 401?
Great question. So we had two 401ks. We had the old 401k that was just sitting there. That's the one we rolled. He had the other one that was still being deposited into. That's the one that had the beneficiary, the girlfriend. So on the new one, when we rolled it to an IRA, I said, who do you want to have as beneficiaries on your IRA? And then we got that straight. That was exactly the same as his will. To include, they said if I die first, what not if I die first? When I die, whatever's left over goes into a trust for my grandchildren. If we didn't have that will in place to actually make sure that all his 401k money rolled through that the way that we wanted to, none of it would happen. So as far as an advisor goes, think about that for a second. I now have assets that will be put into trust until each grandchild turns 25 years old. One grandchild is 2 and the other one's 3. So I'm going to have that 401k money for 20 plus years because I had him sign a will in the 20-day period before he passed away.
You getting this, Randy?
Right? This is how important this stuff is. And it has lasting effect. Okay? So now let's go ahead and talk about the trust mechanism that drives a lot of my questions as far as, okay, we have assets, we know how they're going to be dispersed, but how do I protect them? Not if somebody dies. Well, what happens if somebody gets sick? Okay? And there are a bunch of different numbers as far as the different states. So I'm going to do the presentation as if it was Maine, and then we'll go ahead and do it as if it was New Hampshire, because there's quite a bit of difference, unbelievably, between the two. And what we're talking about is what happens when somebody goes into a nursing home. What happens then? Because the power of attorney and the will, it doesn't matter. The states don't care what you have for wills and power of attorney if you go in a nursing home. They never ask to go ahead and see it because it doesn't matter. They're going to ask you basically one question, and that's how much assets do you have, plain and simple. 85% of the people that go into the nursing home in the state of Maine start off self-pay, right? Anybody have any idea what it costs for a 1 month's nursing home in the state of Maine?
8? Wow.
8?
Wow, 10?
$10,000 a month, right? So, and I don't care how much money you have, it doesn't make any difference. You're gonna blow through these assets so fast,
Oh, yeah.
right? It doesn't matter how many assets you go ahead and have. The government says if you wanna go ahead and apply for help so that you don't pay, but the states pay through Medicaid, because it's a block grant that comes from the federal government to each state, and they say you can be more conservative if you want than these numbers, but you can't be any more expansive, you can't be any more generous than this. And there are two different types of assets. There are exempt assets, which means you can have them and still get help from Medicaid. And there are non-exempt assets, which means if you have them, it's not that the state's gonna come and take them. It just means you don't qualify for any help. You get denied help. It means sell them, you pay your own way. The biggest exempt asset I can have is the house. I can have, in the state of Maine, I can have a house of $800,000 and everything in it, and still qualify for help from Medicaid. So why do we keep on hearing horror stories about mom went in the nursing home, she lost the house? We hear this over and over again. I said you could have the house and get help from the state. I didn't say you could keep it.
That's right.
There's
As
a big,
soon as,
there's a big difference, but I'll show you how to go ahead and protect that. You can have $1,500 worth of cash value life insurance. You can have a car. You can prepay your burial up to $12,000 a piece. Husband and wife, it's $12,000 each, prepay their burial. And if you are married in the state of Maine, you can have $120,000. So, and it's on top of this. So it's the house plus the cash value and the life insurance plus the car, plus the prepaid burial, mortuary trust, and the $120,000. So if two people, husband and wife, can have $120,000, not if, but when one dies, how much can a single person have? It's one person. If two can have 120, one person can have
60?
2,500.
10,000.
Oh, that's right.
Okay?
Oh, my gosh.
So depending on your marital status, as you go ahead and sit here today, everything above either this number if you're married or this number if you're single is at risk. The non-exempt consists of everything else. Camps everybody's got a camp in Maine, and I'm sure that's the case down here in New Hampshire. Vacant land not contiguous with a homestead, so if it didn't touch the same deed as the homestead itself, then it is non-exempt. And then it's everything else, all my cash, CDs, bonds, IRAs, 401ks, everything else. So the question becomes, if I have some of this and I get sick, why don't I simply give it to my kids? That's what my will says. My will says, when I go ahead and pass away, leave everything to my kids. Well, how do you think the state feels about you giving away your stuff to get on their dole? Right? They get a little prickly. So the average person, if I ask the average person on the street, hey, I gave away some stuff, how long do I have to wait before I can get help from the state of Maine? 5 years. That's exactly right. So if I go ahead and start giving away stuff, then I'm going to go ahead and create a 5-year look-back period where I will be denied. But guess what? If I have this, if I hang on to it, and I get sick, I get denied. If I give it away in a 5-year period of time, I get denied. Can you see the urgency here to go ahead and start making a plan? I used to go ahead and wait until my clients were 75, 76 years old before I started doing this type of planning for a couple of reasons. Number one, it was only a 3-year look back, right? And so there's a big difference. But now there's a 5-year look back. The second somebody comes in and rolls over, so I'm gonna go ahead and retire, we set up the buckets to go ahead and start giving people their money, we have this conversation. If you have assets that you wanna go ahead and protect, we need to come up with a plan, okay? So the plan becomes, before I go there, I wanna go ahead and go back to the 5-year look back. When I go ahead and give away money, every single month that I go ahead and give this away, I am one step closer. I'm saving my client $10,000 a month because I have to go ahead and get to 5 years in 1 day. On the Medicaid application, there's a very simple question. And the question is, in the last 5 years, have you given any gifts? Yes? No. It's a very simple question. And it has devastating effects. If you say, yes, in the last 5 years I've given a gift, denied. You get a denial letter in 14 days. Have a nice day. Boom, that's it.
Even for a pair of mittens, because if you check that box, you have no explanations.
It doesn't add,
You're done.
it doesn't give a dollar amount. It doesn't say, did you give more than $500? Did you give more than $1,000? Did you give a car? Did you give a boat? Did you give, in the last 5 years, you made any gifts? If you check yes, right here, you'll get a denial letter. They are looking for reasons to go ahead and deny you. Plain and simple, okay? So the question becomes, okay, I have some stuff. I have assets above 120,000, and I've got some land and that stuff. How do we go ahead and protect those assets? There is only one way, and that is to go ahead and get the assets out of your client's name. They cannot have the assets in the name. And so the only way to do that is either go ahead and gift this to the children now, and what's the downside of that?
They blow it.
Yeah, Steve, you're a genius. I come to you as a financial planner, and your advice to me is to give all my stuff to my kids, right? You never see them again. That's the end of that, right? And plus, there's some real problems with that. If you go ahead and give this asset to your kid, now you could get wrapped up. That's an asset that they can go ahead and get either through bankruptcy, a divorce, or foreclosure, or getting sued through a lawsuit, whatever the case may be. I've never done that. Not one time have I ever given advice, and yeah, we're going to go ahead and give anything to the kids ever. What we do is we set up an irrevocable trust. There's only one type of trust that works, and it's irrevocable. All of my snowbird clients go down to Florida every year. They go to the plate licking seminar with their attorneys, and they come back with these great big fat leather-bound revocable trusts that they paid $2,500 for. And they come back and they're so proud and they lay it down. Steve, look what I got. Look what I bought right here. I said, wow, that's a pretty trust right there. That's awesome. Is that real leather? Look at that. I said, what's in it? What do you mean? I said, what's it? What's a trust? I said, I know it's a trust. What's in it? Nothing. Because the opening letter from the attorney says right in it, as soon as you get home, go to your local attorney and start deeding stuff in this trust. It's just a blank shell. Not only that, because it's revocable, they can put the assets in and turn right around tomorrow, change their mind, and take it out. It doesn't protect the asset against Medicaid in any way, shape, or form, ever. End of story, period. The
What do they think about that $2,500?
oh, they can't believe that they got sold this bill of goods, right? The only reason to have a revocable trust is because you're a resident in the state of Florida, and they will go ahead and charge a percentage of your estate when you go and pass away for probate. That's why they go ahead and do it. But it does not, but some reason they are under the belief that it protects the asset in case somebody gets sick. And nothing could be further from the truth. What's the downside of the irrevocable trust?
Loss of
Well, you
control.
can't get it back.
It's irrevocable. Once the asset goes in, you, as the client that put, or the grantor that puts the stuff inside the trust, you cannot go ahead and call up and say, you know what, I want it all back. Inside the trust, basically you have two different moving parts. And this is the discussion you have to have with the client. The same way that we had that discussion with the will, we're also having it with the trust. Who is going to be the trustee? Usually, it's whomever you've dictated as the power of attorney, right? If you trust them enough to go ahead and make decisions, would be a power of attorney, then you should go ahead and name them as the trustee. The other person is also the personal representative, what we used to call the executor. And we have the beneficiaries. The beneficiaries are almost always the children, right? That's why we're doing this. The trustee is normally one of the children, although it does not have to be. The only person it cannot be is one of the grantors. The husband and wife cannot be the trustee of the trust. So normally we go ahead and name the children as the trustee or one of them. And again, at the same time, we go ahead and name a contingent trustee in case something happens to the first one, or that person isn't around to go ahead and do whatever it needs to be done. So we have a contingent trustee, okay? Inside the trust, we can go ahead and put anything. We can go ahead and put the camp, we can put the house, we can put the vacant land, we can go ahead and put all the non-qualified cash. The only thing we can't put inside the trust
IRA,
is the IRA.
taxable.
As soon as we move it in, then it becomes taxable, okay? So we can go ahead and put all this in there, and we're doing this to do one thing: get the clock started. Every single month that I go ahead and have deeded this in here, the land, the money, whatever the case may be, every month that I've done this, I save my client $10,000 every single month. Is there any advice out there that we can go ahead and give our clients that are gonna save them more or make them more than $10,000 a month? I would submit to you that this is the most important advice you're ever gonna go ahead and give your clients, is to go ahead and get to this level so that we can go ahead and get to 5 years in one day, okay?
Okay, can I ask you, this may sound like a stupid question, but you save them $10,000 a month. I thought if they die in 4 years, you really haven't saved them, they gotta, go ahead. That's
No,
what
go
I
ahead.
want. Yeah, so I'm trying to figure it out.
If they die in 4 years, or if they actually go in a nursing home in 4 years?
Okay, nursing home.
So 4 years from now, great question, 4 years from now, somebody goes and has a stroke and goes to the nursing home. We still have a problem with the question. In the last 5 years, have you given any gifts? The
Right.
answer is yes. But how long do we have to go ahead and pay for mom to be in the nursing home until we can answer no?
1 year?
1 year. We only gotta pay 1 year.
Proactively, who's the one that says we're now in the no box? Do they review this every year?
Yes.
Every single
Great
year?
question. They don't review it every year. This is what happens. You submit the Medicaid application, say, please pay my bill for me. The state looks at this and says, that's fine, we're reviewing your application. Please send us 5 years worth of checking account information every month for 5 years. There's some problems with that. Whatever bank you're using, the chances that they have the same software program for the last 5 years
Yeah.
is non-existent, right? They've changed 3 times by then, and so they can't simply push a button and spit out 5 years worth of checking account and savings account and CD information. So they have to go to their back
Boy,
archives.
they track that, boy, don't they, huh?
Big time. And so I've actually got copies that have been sent from the Department of Human Services to my clients with a list. We need the following things. If we don't receive this in 14 days, you will be denied. 5 years worth of record on. Now, here's the thing. If you have multiple accounts at multiple banks, it will be 5 years on every account. So I literally had a client that came in who had 36 CDs with 36 different banks, because she didn't trust a single bank. And so we had to do that 5 years on 36 banks. You think we can get that done in 14 days? No way, it's not gonna happen, right? And so now you gotta pay another month nursing home, $10,000 in order to go ahead and get applied in time. So what part of the planning process is that, and this is a great way to go ahead and mine for assets, is you're asking your clients, how many accounts do you have out there? And sometimes they're hesitant to tell you that, but as soon as you tell them this, say, the reason I'm asking isn't because I necessarily want you to give me all the money. Well, ultimately, that's what we're after. But I need to know, because if you have all these accounts out here, you need one checking account and one savings account. That's it. You don't need a checking account with this bank and one with that bank and one in Florida and one all. You need to start minimizing the number of accounts that are out there, okay? This will motivate them to go ahead and take action in order to go ahead and start minimizing accounts, consolidating with you, hopefully, on a regular basis. Let's go ahead and talk about before I forget, let's talk about the New Hampshire numbers, because the New Hampshire numbers are drastically different. In New Hampshire, what they go ahead and say is that the community spouse, so we have two different active players. We have the community spouse, the one who's not in the nursing home, and we have the nursing home spouse. Nursing home spouse. That's the person who's in the nursing home. The community spouse can go ahead and have half of whatever assets, whatever non-exempt assets are out there, up to the $120,000.
Including the land.
Any assets up to $120,000. The real number is $119,220. That's the actual number, but we rounded off to $120,000. So if I have $200,000 worth of assets, the community spouse can have half of that. So that, in this particular scenario, the community spouse can have $100,000. So they can have half of the number up to a maximum of $120,000. So if the couple comes in and they have $100,000, then the community spouse can have $50,000, right? That's how that works. So it's drastically different than any other state out there. No other state does it that way that I'm aware of. And instead of the single person having $10,000, you can only have $2,000. There's the deal. So here's the thing. If you are single and get sick, you will lose all of your assets. Because this is what happens. Let's say that we do all this and we get beyond the 5-year, Medicaid starts paying for us and we run up a bill. Because instead of us paying $10,000 a month, now the state is paying for us. And let's say we run up a bill for $100,000 and we die. If there is a community spouse left, then they simply go ahead and erase the board. They say, nope, you don't owe us anything. On the single person, if I have a $100,000 debt, they come and attach everything on the exempt side. So I said you could have it and get help from the state. I didn't say you could keep it, because when you die, whatever you owe, you're going to have to go ahead and sell. Your estate is going to have to go ahead and sell and pay back the state. So what they do is, as soon as there's a death, they fax that Social Security number down to DHS and says, does this Social Security number owe the state of Maine or state of New Hampshire any money? If it's yes, they attach everything that's going through probate. The reason the irrevocable trust works is that anything inside the trust does not go through probate.
Oh.
That's why they can't attach it. Okay? So even if you don't have a whole pile of assets,
And even if it doesn't go 5 years, right? I mean.
right? No, absolutely. Even if you don't have a whole pile of assets, or if it doesn't go 5 years, anything that's inside the trust does not go through probate.
that's worth paying for the trust, just,
I just had a phone call, literally, I just had a phone call a couple weeks ago where the mom passes away, she's the single person. The trustee, who's the daughter, calls me, says, Steve, mom passed away. I said, I'm sorry to hear about that. But now what do? There was some money left in there, and there was the house that was left in there. The trustee simply will go ahead and deed the house to the beneficiary, which was her. So as a trustee, she's gonna go ahead and deed from the so-and-so family trust to her, and we're gonna go ahead and send all the money to her. No attorneys, no court, no probate court, no anything. She says, yeah, but there's gotta be more. No, that's it. We did a little bit of planning, and now you're gonna reap those benefits. It's so easy that even if you weren't worried about the Medicaid going in the nursing home thing, let's say that this is still worth it to go ahead and set up the trust. I call this the bulletproof box. Once it's in there, nobody can touch it. Everybody thinks that somehow the state is gonna come in and take your stuff away from you, and that's not the way it works. The way it works is you're simply gonna be denied any help, any funding from them if you have certain assets. Questions?
that just cut right there.
Do you have cases where clients will need money from that irrevocable trust to fund their
Yes.
retirement?
Great question. So number one, we never go ahead and put all of the money in the trust. We just never do that. That is not the goal. Couple of things. Number one, the grantor, remember how I said the grantor cannot go ahead and get the money back out of the trust? They do get all of the income or all of the gain. So let me give you an example. We go ahead and we put the house in and we say the house is worth $100,000. And 10 years goes by and the house is now worth $150,000. And they sell the house. That $50,000 is now considered a gain and they can go ahead and take that back out. So any money that's kicking off interest flows back to them through their Social Security number. So they have all of the gains and interest and all the dividends, but also on the hard assets, anything that is a gain can come up.
Did not know that.
Yep. And it's kind of important because upon this, one of the death, and we have some of the income, the direct income goes away, we lose a Social Security check or a pension that goes away because of death of the spouse, we may have to go ahead and start getting some money out of this trust to go ahead and keep mom or dad home, right? It's important to go ahead and have some way that we can go ahead and turn that faucet back on to get them some money, okay?
So what are your thresholds for money? Up in Maine, it's the 120,000?
120, yep.
Cash
Yep.
that you keep out in New Hampshire?
So
Whatever 50% is?
whatever 50% is, but what I try to encourage people to think about, it all depends on how much you got. Let's say that somebody comes in and we've got $300,000, right? I would go ahead and try to encourage them to put a fairly large chunk of that in here. And when they say, well, what if I need money? Yeah, if you need money, we need to get you down below, not the 120, but we need to get you down to 10,000. That's the number we are, because one of you will pass away before the other one, I promise you that. So we'll put a bunch of money into the trust to go ahead and get the clock ticking, and then we'll concentrate on the remaining money to actually dwindle it down on purpose while we're building up, while we're growing it on this side. Okay?
And, I mean, what are you utilizing in the trust for the investment?
So it all depends if we want interest to be given back, which is almost never the case in the beginning. So what we'll go ahead and do, and this is a really great place to go ahead and put a fixed indexed annuity with a increasing death benefit. There are ones out there that will go ahead and actually pay or increase the death benefit by 7%. Because the goal is to get as much money to the beneficiaries as possible. So we can put it into the fixed annuity, guarantee they can't lose, 7% increase, so instead of leaving them 100%, we're gonna leave them 170%, because it goes up for 10 years running. And if it's inside there, we're kicking off no gains, right? No interest, so there's no
Tax.
money that we have to go ahead and give back.
Trust owns it,
Trust owns it.
who's the annuitant?
The annuitant will be the grantors who are putting the money in, and the
So if it
beneficiary.
wasn't an annuity, tell me again, what would happen?
So you could just have a regular brokerage account inside the trust, and you put whatever you want. And then you can control, if you don't want any gains, put it all in, or taxable gains, put it all in municipal bonds, right? Or you can have stocks that have dividends, it all depends on how much dividends you want kicking off.
But the distribution is gonna come out.
Yes, the distribution, if you leave it in there, then it gets taxed at the
35.
trust rate. Never happens, it's always gonna be given back to the thing. But what you don't wanna do is put a pile of money in there and then have all this gain, all this interest come out and put it back on the table. Because you don't want, now, I gotta get rid of that money too, and it starts a 5-year clock all over again. For every time that we go ahead and add money to the trust, that money's brand new, starts that 5-year look back all over again. So you don't wanna go ahead and have money being circulated back. The only time you do that is if they need the cash to live on, that they're gonna go ahead and spend it, okay?
Yeah, because once it's in the trust, it belongs to the kids.
Yep, that's the goal. There's ways to go ahead and circumvent it, meaning that, let's say that mom needed a new car, you could go ahead and take some of the money, give it to the trustee, and the trustee could go ahead and give it to mom. There's a way to go ahead and do that. You can't give it directly from the trust to mom, but you could go to make a
Which
gift to
would
the
be the
trustee.
kid.
Yep,
That's the health, well-being, all that
Yep.
5%,
So-
above the 5% stuff.
so what'll happen is that you can always go ahead and make a gift to the trustee, and the trustee can give the money to mom. That's the way to go ahead and do it, but you should be planning on that anyways. There should be plenty of money left outside the trust, so that never happens. But just in case, it's a fail-safe to go ahead and do it that way. And
So the cap's 5% a year.
no cap, there's no cap.
Why'd you, what's this 5%?
That's,
Well, that's for what? Just
yeah, the
the,
health, education, maintenance and
Maintenance, yeah.
support, yeah, that's a little, I don't think you're using those exact.
Those in the
I
marital
think
trust
you
side?
just, yeah,
Yeah.
you can just do the gift.
Yep, you just make the gift. Yep, so no problem there. So the question is, and so is there any,
No, that annuity with the 7% uptick every year. What a
Yeah.
wonderful way to increase.
on the distribution of whatever, gift to the trustee gives it to back to the grantor and says, here's your money
yep,
to spend. Taxation on there? What's the?
sure, that somebody's gonna pay if there's any gain, right? Somebody's gonna pay, either the trust is gonna go ahead and pay, or the grantor is gonna go ahead and pay. So there's gonna be a 1099 given to somebody.
It's always a LIFO.
Yes, it's always LIFO, yep. So,
What's the tax on the trust?
35%, right? Marie, is it 35%? Yeah. So you,
You don't want to be tapping
yeah,
that.
no, it's all gonna flow back to their, it's gonna be
But in
their
an
tax rate.
emergency, it's good to
Yeah.
know you can.
Yeah. So if there's no other questions about this, I want to go ahead and show you a scenario. This is a planning. Everything that we've done so far is we've talked about planning. And I just want to take 2 seconds, and this is something that you would never share with the public as far as a seminar goes. But I want you to go ahead and understand what happens if somebody gets sick who hasn't done any planning. Okay? We have, oh, let me go ahead and make a bigger spot here.
Now you say client to a nursing home without any planning.
Yes, this happens all the time. This happens to me twice a month. People call up and say, Steve, went to your seminar, didn't take a word of your advice, and mom just got sick, right? What do we do now? No planning, right? 5-year look back. Mom's in the nursing home, she had a stroke, this is it. So back to our spouses, we have the community spouse and we have the nursing home spouse. The community spouse in the state of Maine can have $120,000. Let's say that the nursing home spouse can only have $10,000. So what you do is you liquidate all of the nursing home spouse's money down to $10,000 by gifting it back to the community spouse. So if we have IRAs, we liquidate it to cash. If we have CDs, whatever the case may be, we liquidate all of that. We get it into the community spouse's name and we put it into an immediate annuity. Usually it's for a 4 to 5 year period of time. The higher the interest rates, the shorter the period of time it is. Right now, it's the longest it's ever been. And I think that we're somewhere around 5 years is the shortest we can go ahead and get it. So I can take an unlimited amount of money, put it into an immediate annuity right today, give the community spouse a monthly check, and qualify the nursing home spouse immediately.
Will the state take some of that annuity?
No, because the state is all based on asset base, and we're taking an asset and turning into income.
Oh my gosh,
So the community spouse can have an unlimited amount of income
in Maine,
anywhere,
In New Hampshire.
anywhere.
great idea.
Yeah.
Oh my gosh.
So what happens is, but this only works if there's two people, okay? And the other thing is that if the community spouse dies before the 5 years is up, the state gets the income going forward. They have to be named as the beneficiary, it has to be irrevocable, so you can't change it, okay? So I just want all the advisors out there to know that there is a last chance effort in case nobody takes your advice, that you have to go ahead and go back
Yeah,
to.
but you've done your job, you protected that other spouse.
Sure, absolutely, but this is we can get you qualified in 30 days. By the time we go ahead and move, and I've got 3 clients as we sit here today that I am doing this with, and we'll do it all before December 31st. Actually, we'll go ahead
And
and.
you get paid for helping people.
Yeah, there's nothing in the financial planning world that you are gonna go ahead and salvage more of people's assets. I mean, the mistake I made 22 years ago was not keeping track of how much these assets were worth that I have salvaged. Because when I say that I have salvaged hundreds of millions of dollars, it sounds like a lot. It really isn't. If I get a client who's got $400,000 in cash, a camp on the lake, and a house, it's an easy $1 million. And if I do 2 of these a week, we're doing hundreds of millions of dollars of assets that would have been liquidated and given to the nursing home. I keep looking for a target on my back to make sure that, they're.
Yeah, I was just
giving
thinking,
us like-
state sends out a hit.
Yeah,
So what else are you doing there, Steve, with all the other assets? So let's assume that there's a house, let's assume that there's, the camp, and all those things in joint.
so if there is a camp, that's gonna have to be liquidated and turned into cash in order to go ahead and get to here.
Right.
Because that's a non-exempt asset.
Right.
It goes back to exempt versus non-exempt. So what we need to go ahead and do is we need to get all the non-exempt into the exempt, and the only way to go ahead and do that is turn that into cash and go to a monthly payment to the community spouse. At this point, these are tough conversations to have because I always get this pushback by the community spouse who says, well, that's not what I want. At this point, it doesn't matter what you want. If you should have been in and taken all my advice 5 years ago, this is what you want. Now, this is what you have to do, or you simply start liquidating everything here and giving it to the nursing home at $10,000 a month. That's your only other choice.
What do you find is the most, their hope? Well, he may not last long in the nursing.
Yes.
Okay, right?
Yep,
Maybe he'll keel over tomorrow.
yep.
What are the objections you get at that stage that people are saying, I just don't want to do? Or I can't sell camp, or, the house we want to give to the kids,
Yep, no, that's fine. You say, I don't want to go ahead and sell the camp. That's okay, that's all right. Nobody's going to force you to go and do that. You pay. That's the only other option. You hang on to the non-exempt asset, you pay $10,000 a month. We don't have $10,000 a month, then sell the camp. That's the only 2 options there are. There are no other options. It's not like, Steve, could you please give us the list of options that we can choose from this menu? No, those days are over. Give you a real example, this just happened. Client comes in and he says, you probably don't remember me, I was in here 4 years ago with my mother. And you told us about the trust and all that stuff. I said, oh, great. I said, and how much of that did you do? Nothing, not one thing.
His
And I
mother
said,
wouldn't let him do it?
Mom didn't want to do it. Now, this is something that if you start down this road, you're gonna have to get used to it. It took me a long time to get over this, because I believe this is the right thing to do. It's still their money. And they say, I am never giving up control of this. I will roll the dice and risk it, and she did. And I said, okay, so what happened? Well, Dad died. Mom's now in the nursing home. What are our options? And I literally said this to him. I said, right across the street, there's a hardware store. You go across into the hardware store, aisle 14, 3/4 of the way down on the third shelf are for sale signs. Go get a pile of them and start selling everything your mother has. The house, her car, sell everything, because she's gonna lose it all. I thought he was gonna pass out, right? He thought I was kidding.
So walk us through the single. So,
Yep.
you know, we've got a community spouse here, but let's assume that we have now a
Yep.
widow
Yep.
who says, you know, I really wanted my kids to get this stuff, and now
Yes.
I've got, what do I do?
Then you put it
Or
in
the
the
son
trust.
comes to me and says,
You put it in the trust. So if you have a single person, there's only one salvation, and that is the trust. It's the only hope.
and hope for 5 years.
And hope for 5 years. So what happens if it doesn't? What happens if it doesn't make the 5 years? You got a choice, right? The trust can go ahead and sell everything that's inside there. Let's say that we've got the house, and here's another example, just happened. I don't have to go back very far to go ahead and give you guys real examples of real clients that this is affecting. We put the house and the camp in there. 8 months into doing it, mom gets sick, goes to nursing home. It was the camp that they wanted. They didn't want the house anyways. The camp in our territory is always worth more if it's on waterfront
Yeah.
than the house ever thought of it, right?
That's the same here in New Hampshire.
Same here. So what they did is they simply sold the house and had the trust pay for mom to be in the nursing home. That's all. They sold the house, turned it to cash, and every month, and hopefully they go ahead and get down, there's 1 month further, so that they can salvage the camp. If they run out of money and they have to keep it there, then probably the two brothers are gonna have to buy the camp from the trust, and they're gonna have to go ahead and pay for it that way.
Yeah, so at the single stage, you're just walking on hope for the 5-year window. That's
Yes.
all you got.
Yeah.
If
So
you can't, you're self-paying until.
Okay,
then.
they changed it from 3 to 5. Do you ever see a day when the state's losing money, they're gonna take that 5-year look away? They're gonna just say,
no, they'll go to 7, this is what they'll do.
Yeah.
Yeah.
They'll go to 7,
Proposed
there's no
7,
question about
haven't
it.
they'll go to 7 or
They
then?
Sure.
proposed 7.
No, they're going
I
to
think
7.
I've heard it, yeah.
And now, but whatever's in there, it'll be grandfathered. When they go to 7, whatever's in there.
Yes, I actually kept a list of all the clients that I talked to about this, and they were thinking, back when it was 3 years.
Yep.
And they're thinking about it, blah, blah, blah. And I called them on the phone when this law was coming out, right, because they passed it in like July, but it wasn't gonna go into effect to that, and so, until the next year,
Right.
January 1st. And so to go from 3 to 5. And so we just did as many as we could go, because we knew they'd be grandfathered. There's a big difference between 3 and 5
Oh,
years
no
when
kidding.
you're 80 years old, right?
Because they can keep somebody on a respirator.
Yeah. Well, there's another reason to go ahead and
then you're having an
have one of
argument with
these,
the
right, with a
medical
power of
guy.
attorney, right? That's why you have the medical power of attorney, right?
I wouldn't want to be on a respirator, I
Yep.
can tell you that.
Any questions? So the only thing that we've done, at the seminar, I go ahead and I have one goal, and that's to give them enough information to make one decision. They don't make all this decision, who's gonna be the trustee, who's gonna be the
Right,
beneficiary,
right,
none of
right.
that. I make them, they need to make one decision. Do they need to make an appointment with me? I've given them just enough information to say, I need to go see Steve.
Yeah.
Man, this is way over my head,
Oh,
I need
yeah.
to go see him. They come in, then I go ahead and do the complete fact find, where are all your assets? How do we go ahead and set this up? Should it be an irrevocable trust? And what's it gonna cost to go ahead and make this whole thing happen? And at the same time, do you want me to help you with the power of attorneys in the will? Do you wanna go ahead and get one of these cards that has all your medical information on it? Do you want help with this, yes or no? If the answer is no, we're gonna do it on our own, hey, nice meeting you, have a nice day.
Yeah.
I've had great success. Every single person that comes through the door who makes the appointment says, sign us up.
Yeah, why would they take your information and?
How do you document those that say, we'll think about it and walk away? Are they
I
signing something?
don't sign it, I don't send anything, I do no follow-up whatsoever. Because once you turn this on,
Yeah.
they're gonna talk to other people, they're all in the same age bracket, they're all talking to each other, and you're gonna get way more clients than you want doing this stuff, right? I do this as an add-on, I don't wanna get up every day and do this. This is part that I'm doing. If you're not doing this for your clients, if we go ahead and do the financial profile, we do the plan, and we get them to the 10-yard line, and then we lose all their money to the nursing home, shame on you. Shame on you for not doing it right. Don't call yourself a planner. Call yourself something else.
But from the perspective of them saying, thank you, we'll think about it,
Yep.
you having them wave off, sign a thing, and walk
Nope.
out the door? Nothing?
Nothing.
Okay.
Nope, I gave them the
But you can
information.
do that, George, if you'd like.
I'm just wondering,
Nope, I've given the information.
because I know how much you love attorneys.
I don't know how that ever got started. I can't imagine how that ever got started, that I don't like attorneys just because I'm calling a bunch of bottom feeders, bottom feeder bastards. But listen, it's important to go ahead and have the attorney relationship because, and this is why it's so important to do this type of stuff, is that you need to go ahead and continue to feed the bottom feeders, right? And because by doing that, you have a relationship so that when it comes time to, when you pick up the phone, you make the call, they'll take your call and they'll return your call. And the other thing is they should be returning that with some real good referrals your way.
Reciprocal stuff.
Yeah. The last attorney that I launched, she actually sent her parents to me. 1.5 million rollover.
She probably figured you know more about it than she does.
No, she does. No question about it. She knows that I know more.
What was the, what process did you use for the attorneys in the areas where you're now going to and work doing these things?
That was going back to your question, is how do you launch the attorney?
That's right.
Okay, so this is this is on the advisor side. How do you go ahead and actually make that first phone call? How do you get the attorney? This is what the phone call sounds like. You get the list, and the type of attorney that you want is not trial attorney. You're looking for a state attorney, ones that do power of attorneys, wills, deeds, real estate guys. Estate attorneys, that's what you're looking for. You don't want a long-term care attorney because they don't want you in the loop, right? They want to take all the business for themselves. They don't
Yep.
want you.
Yep.
So you find this guy, and the way that you do, or the person, you pick up the phone and you go, hey, is this Dewey, Suam, and Howe? Yeah, I need to go ahead and talk to Dewey. Okay, so you go ahead and talk to Dewey and say, listen, I'm a financial planner in the area, and this are the key words. I need an outlet for all of my clients, power of attorney, wills, deeds, and trusts. Are you that person, or should we go ahead and talk to somebody else? Yep, I'm your guy. Great, I'd like to go ahead and meet. You set up a time to go meet with them, and you go with that sit down, and you start asking them, say, what is your scenario, or what is your solution? If I bring a client in that has this much assets, and you make up the numbers, say he's got $200,000 CD, and we've got a camp and a house, what would your recommendations be? You need to test them and make sure that you're on the same page. Because if you get somebody that says, nope, I think they should just go ahead and self-pay, he's not your guy. And I've actually had these people tell me this, right? So you need to go ahead and have the person, the right answer is, well, we set up the irrevocable trust, we deed everything in there as soon as possible, get the clock ticking, that's the right answer. When you find that person, then you're gonna go ahead and take your clients, you're gonna take their information, you're gonna walk through the door to that attorney, and you're gonna have a working relationship with them to say, hey, I'm gonna start sending you clients. You wanna be there at least for the first 2 or 3 to make sure it's going smoothly, right? So everything's going right.
So you have 1 or 2 attorneys, or how many attorneys do you have that you, just one?
So they come and go, and I've had good ones and I've had really bad ones, and because of my credit unions are so far apart,
I got you.
what I've actually done, my latest attempt, is that I actually go ahead and meet with a client, I collect all their information. I determine, yep, they need a trust. I take, what will the trust name be? Oh, it'll be the Dean Family Trust, and we're going to write that in. Who's going to be the trustee? And what's their address? And I would take all that information down, and I hand deliver that to the attorney.
So you saved him a ton of work.
Right.
Yeah.
The attorney, now I charge my client $500 to walk them through this. I give it to
Does that
them.
include this?
That does not include this, not include the key. This is new. I haven't actually done this with a client yet, but I'm going to.
Okay. Will that add $100?
It will, per key.
Yep.
Yep, no question. So the attorney now has this. They're gonna send my client an engagement letter that says, Steve says you wanna do this trust, is that true? Do we have the names and addresses right, all that type of stuff? Yes, that's exactly right. They send the engagement letter back, go ahead and do the trust. She does all the drafts. Sends the draft to the client. Did we get the address right? Is this deed look right? Is this all right? Yeah, okay, looks good. Make an appointment, and for the first time, they come and drive an hour one way to the attorney's office to sign the document. First time they ever meet the attorney, but they're gonna sign the document and they're gonna walk out with the originals, power of attorney, wills, and the trust. Now it's all ready to go.
And have you negotiated any specific type of pricing for?
I did. This is why my clients are willing to go ahead and make the travel an hour one way, is because the typical trust will cost anywhere between $2,500 and $3,500. So the local attorneys where my credit unions are, they want to charge $3,500. My attorney in my hometown has negotiated, I've negotiated with her $1,000 for the trust by deeding one property in. If you have more than one property, right? I had one that literally had 9 pieces of property. Hey, it's $200 a deed, it's gonna be whatever it's gonna be, right? So I've negotiated that
So
because.
$3,000.
So I've negotiated, because I'm doing a lot of the work, and the fact that I'm making it up in volume. I mean, this stuff is not hard. This is word processing, right? And guess what? The attorneys aren't doing it anyways. The secretaries are doing all the work.
Right.
Right? So the attorneys, this is just pushing the button, right? This is a huge printing press for them, and they're just kicking out thousands of
So
dollars.
they technically saved, I mean, look, 500 to you, now maybe 700,
Yep.
but their house is in order, Steve.
So, and you're doing, they have to all have DPOA, will, trust, all three, everything.
No, sometimes, no, I'll give you another example, and this is, I think where a lot of the younger people, the younger advisors make a mistake, is that they'll meet with a younger person and they don't have a 401k to roll or whatever, and they just kick them out the door. That's a huge mistake. They still need, and I'll give you an example, last week, client comes in, he's 35 years old, stay-at-home, wife is a stay-at-home mom, one child. Do you have a will? Nope, no will. Power of attorney? No power of attorney. Medical? Nope, no medical. They don't need a trust because they have no assets put in it.
Right.
But they need the other thing. What's the other thing the 35-year-old with a child needs?
Guardianship?
Guardianship? No. Life insurance.
Oh, sure.
Sold them $1 million term policy. Right? So that now by doing that, I've protected those clients. Because the most important thing that young couple's going to go ahead and name in the will is what? If something happens to us, who takes care of our child? There's nothing, as a parent, there's nothing more important than that. Without a will, then it's just up to the state
So
to
then
decide.
it'll create, the will create a trust for that,
Yes.
the assets to
For the child, so the life insurance will then go into they call it a pour-over will, into the trust. So the $1 million will go ahead and end up, first beneficiary will obviously be her, and then the second beneficiary will be the trust.
How would you do this with a business? I got a business owner coming in today. They're just buying a house because they're coming from a previous marriage. Both of them had 2 children each marriage. But she said, I want to do some planning. I want to do some, and I made it after this,
Yep.
so it'd be
Yes.
fresh in my mind.
No, the trust works the best with his and her kids, because there's so many times you go ahead and see that go awry. So you go ahead and say, okay, whatever joint assets we've got, we're gonna go ahead and put into the trust, and then the beneficiaries, you make a decision, will be liquidated and turned to cash, and this is how we're gonna divvy it up. Or, in the trust document itself, where you say, this piece of property goes to that child, this piece of property goes to that
And
child,
that's in the trust.
it's in the trust. Yep. Now, the other thing that I failed to mention on the will is that all states, I shouldn't say all states, but most certainly, I believe Maine and New Hampshire, allows a list to be attached to the will for personal property. So you can list, typed and then signed by the person.
Shirley gets the necklace.
Yep. Who gets the gun, the wristwatch,
How
the
does
dishes.
probate work with that? Like, if there's a list of things on that will, why would that have to go through, it does have to go through
It's the only
probate.
place the will
Personal-
gets done.
Personal property doesn't necessarily go through probate. It's up to the personal representative to distribute that properly. Okay?
So no probate for that.
No probate.
So the probate would be for the checking account if it's not in a trust, trucks, cars, things like.
If you have assets over a certain dollar amount, the state of Maine is $20,000, then you have to probate the estate. If it's under $20,000, you don't have to do
What
anything.
about New Hampshire?
I'm really not sure on New Hampshire. I wouldn't go ahead and guess on that.
You do when you, well, this is I don't know if we're done with the recording. But if you have a client who passed away, everything was joint and they had no will, what's your recommendation from the court, the county, do you say go and file the intestate, just file a copy of the death certificate, anything?
No.
You don't give them any, you don't start a clock for that 9 months?
No, there's not real,
Creditor.
if everything is joint, there's no real need to go ahead and do that, because everything upon last death transfers to that other person. The question becomes, if that person didn't have a will, does this person now have a will? This is when it's important, because when last breath of this one, now you're in trouble, because nothing's right.
Yeah, I'm just wondering from a creditor perspective, if that person said, somebody comes as a claim and says, hey, Joe died 6 months ago, he owed me $25,000 for a job I did for him, and there's no money left for him, it's all joint. Is that a creditor that then could come? I mean, so in other words, do we start the clock for the filing? Probably an attorney question.
Definitely an attorney question, yep, definitely.
Thank you, Steve.
Yep, you're more than welcome, I hope that helped.
Just-
Now, are we getting a copy of that, or?
I got copies of, these are actually my own personal healthcare, medical power of attorney, durable power of attorney, and my will. This is my own personal stuff, which you guys can have.
Thank
So
you.
that, and
Can
this
I write
is,
myself in there for anything?
yeah, absolutely, change it as you go on, yeah. And this is the,
Thank you.
this is on the key
I actually
itself.
have that, I actually got that.
So this is just the printout of the key, what it actually shows, and